Sandals executives no longer have to answer to charges of intimidation and termination of employees, as well as failure to enter into contract negotiations, as a noli prosequi has been signed. This means that criminal proceedings against them have been discontinued.
Now, the resort's general manager and financial controller were arraigned before the courts last month and faced $5,000 fines or a year in prison if found guilty. Clint Watson spoke with the lawyer representing Sandals on the new developments.
The sign noli prosequi by the Attorney General in relation to the court matter where Sandals executives were charged has raised eyebrows. But attorney for Sandals, Wayne Munro, explained why the order was sanctioned.
The complaint was against the company that is Sandals and against two Sandals employees, because the two persons charged were employees. They were not owners of the company. They were not mentioned in the complaint, either by name or position, and they were just thrown on. I know as a fact that contact was made with the Office of the Attorney General to draw to their attention that they full know that the issue of the existence of this union is being tried before the Supreme Court in a judicial review matter.
In essence, Sandals' petition is that the Director of Labor failed to do his job in striking this union off the register for not complying with the rules to be a trade union, and this complaint is about failing to negotiate with this trade union. Munro says all sides are aware this case is before the courts, including the AG's office.
And so it would have been an abuse of the process of the magistrate's court for a magistrate to have to come to a conclusion that this union is a union when that same question is being tried before the Supreme Court. In my view, it looks as if it is an attempt at blackmailing the employer into negotiating with you and waiving their rights to say you are not a union because of your failure to comply with mandatory provisions of the law.
Aside from omitting the other case under review, Munro also lists other reasons why the case was discontinued.
Another ground of our attack was that when you look at the complaint, one of the charges is statute barred. It's outside of the 6 months in any event, and we say the magistrate was wrong in doing that. And when you look at the other charges, there is no sworn material that supports them. And so, for instance, I represent Sandals, not the GM and financial controller, but those fellas' names aren't mentioned at all. Nobody calls their name, nobody calls their positions. And so we in the judicial review say the magistrate was wrong in issuing the summons and commencing the prosecution, and we were moving, and we may still move to quash the entire process.
Munro clarified that the matter would have been back in court today, but since the filing of the noli prosequi, it would nullify the Attorney General's office from having to pay costs to Sandals' attorneys if they were instructed to proceed with the matter. He suggests if the union feels so strongly about the matter, they should put themselves on the line and pay the costs. Munro is also making further aspersions regarding the union and addressing the issue of union busting. We'll have that in our next story. Clint Watson, ZNS Network News.